What's up, everybody? Welcome back to the case that just won't quite end, as we have a motion to dismiss after a mistrial has been declared based on potential juror comments and votes on multiple charges against Karen Reed. We are going to read the motion to dismiss today. We're going to read the affidavits of Jackson and Yanetti. We're going to find out what the jurors allegedly said and how strong this type of evidence actually is. And we're also going to discuss what the potential next steps are to get to the bottom of this, because the point is truth and justice, the correct result, the fair result, the true result. And I also have a special guest that's going to be joining me today that I don't think has joined me at all throughout the trial. You guys are going to want to know his comments. So we're going to bring him in, talk to him a little bit, get his feel on this motion, what he expects to happen as well. So get ready. Hit the like button, subscribe if you haven't already. Let's get into it. Yes, I also did see the Proctor news. We'll maybe talk about that at the end or do a different video to talk about that. But today we're really going to focus on this motion to dismiss. And if you guys remember, if you've been here since before the Karen Reed trial, basically the only thing we talked about prior to the trial starting was the FBI investigation. How wild that is that this is happening, how different it is, how unique it makes this case. And to discuss that and to break that down, I didn't know anything about the case. I didn't know any of the facts. And so we brought in my dad to talk about it because he had been a federal prosecutor, state prosecutor, worked with the FBI. We do federal criminal defense as well, working, with and against the FBI on those cases. And just to talk about the unique situation that creates when the FBI is investigating the investigation. So then the trial comes, we do the trial. My dad was kind of in and out on the trial, didn't follow it completely, but followed it enough to kind of know what's going on. And after the fact, actually, when the jury slip issue came up, I talked about it a little bit with him, gave you some of his opinions on that. And he and I were actually planning to do a live today at 3:00 on the YSL trial. There are some updates there. We're still going to record a video later. And I said, hey, let me send you this motion to dismiss. Let's talk about it. And so he decided to read it. And now we've got my dad on here, who, as I said, former federal prosecutor, former state prosecutor, and then criminal defense lawyer for the last 40 years. So right in the wheelhouse of, what you're dealing with, what we deal with on cases. But this is very unusual. This is very unique. I guess I don't even ask you this. Has this type of situation ever come up to you before, where you've had a mistrial, where you have believed that the jurors actually should have come to a vote on one or more of the charges that you found out about after the fact?
No, it's never happened. Usually what happens is a juror will call you and tell you about misconduct in the jury room, where a juror went on their own and went to the scene of the crime, or where a juror did their own research on Google. That kind of impropriety you hear about, and then you file a motion to dismiss, or motions like this to question the jury, the same kind of results, but never a situation of double jeopardy. That one has been, that's a new one.
Yeah, and there's a case, this Bluford v. Arkansas case that they cite seems to be on point. We're going to talk about it and we're going to dig into it, because there were some really interesting things that came out from the affidavit and from the motion to dismiss that I thought were obviously positive for the Karen Reed crowd and team, but a lot of negative as well. There were a lot of things that I don't think they were happy to see in there, that I don't think even they can claim as some kind of victory, which lawyers are known to do at any point in a trial. Something goes your way, you claim victory, you take the victory lap. So I get it. And that's what basically every lawyer does in a trial when you don't lose, and you can spin it as some kind of a win for you. But I thought this motion and the affidavits were different than I expected. So, oh, great. We're having an issue here with the super chats, which is going to make for a long. All right. So I'm going to bring it up here, and we're going to take a read. And actually, I'm going to have to, let's take a read of it now. So, okay, here we go. John and Kelsey, make sure you guys star the questions and super chats and stuff, because they're not automatically starring on mine. All right, the defendant, Karen Reed's motion to dismiss. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court, pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights, to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and alternatively, because there was no manifest necessary supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both the federal and state constitutions. All right, hold on. We're having a technical issue. I got to refresh my screen, see if that fixes it. All right. Sorry, we'll see if this fixes it. Yes, that fixed it. Sorry, guys. All right. You can hear me, Dad?
Yes.
All right. All right, so here we go. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Okay, and this language about prosecutorial misconduct and what a prosecutor is supposed to do and what the prosecutor's duty is going to be important in at least some of my thoughts later on how all this should turn out, how all this could turn out. Prominent among the reasons colonists cited the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them in many cases of the benefits of a trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The double jeopardy clause provides that no person shall be in subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Here, the very day after the mistrial was declared, undersigned counsel began receiving unsolicited communication from 3 of the 12 deliberating jurors. So before we get into what they found out or what changed or what happened, what is your thought just about the first 2 pages, the history lesson, the double jeopardy, the protections it provides, the Constitution, federal and state? As a criminal defense lawyer, how much do you enjoy writing motions like this, like they write, especially when you feel like you have something where this could be a really big deal and this could be a really big swing in a case like this?
Well, you always enjoy the chance to write prose. And it sounds very nice, and it is the basis for everything we believe. I'm sure the judge doesn't need to be reminded of all this, but you always put that in because you don't want to ever have somebody say to you, you waived that. You didn't put that in your motion, therefore you can't argue it. So they cover the whole gamut of the Constitution in order to make sure that they've covered all the constitutional rights of their client, because this motion is based on a constitutional violation. So they had to make sure they did it. They made sure it sounded good, and they made sure they covered their bases, and that was the point. Yeah,
and I think a lot of what they've done also is maybe educating the public or doing it because they know there's going to be public eyes on this, news stations, media covering it, and that doesn't hurt.
No.
Okay, so let's keep going now and figure out what they learned from a quarter of the jury. So 3 out of 12. First off, let me just ask you this, okay? Without, even really getting into the facts of the case, 3 out of 12 jurors. Does that strike you as a large number, a small number, kind of what you'd expect in this situation? All the high-profile nature of the case, all the things going on in the media, I at least have to guess, just based on my experience on covering cases, and seeing what happens in the fallout, especially the high profile ones, how a lot of people involved in the case will even reach out to me who has nothing to do with the case. So for them to reach out to the lawyers on a high profile case like this, where does 3 rank in kind of what you expected, or more or less than you would expect to reach out to the lawyers on the case?
It may be a little more, but keep in mind, and you'll see later, we're not really saying 3 jurors actually reach out to the lawyers. That's not what really happened. 2 are indirect and 1 is direct. So we really don't know the full gamut of what's really happening. So
exactly.
Yeah. So yes, if 3 jurors called me on a case, I would say that was unusual. But
yeah, especially what happened when we're talking about us, sure, and just kind of a normal run of the mill case. But when you have one in today's day and age with the YouTube and the media and all that stuff happening, in my opinion, it's I guess kind of around what I would have expected. I expected jurors to reach out to them. In our cases, I think the most I've talked to jurors right after the trial that wanted to sit and talk about it, and I've talked to the whole panel before of 6 jurors on a case. But after a trial, usually, I mean, I don't know if I've ever had more than 1 call our office to talk about it. Just from my perspective, I don't know if you've had more than that.
I've had more than 1. I've had a couple cases. I can't remember 3. I can remember 2 for sure. A couple cases where I've had 2. I can't remember 3. Now, what happens, I'll tell you, a lot of times what happens is when you're standing outside the courthouse and the jurors come out, and normally it's a not guilty verdict. The jurors come out on a not guilty verdict. Those jurors come over as a group, and I've had them, the whole jury, come over and talk to me after the not guilty verdict. Now, that has happened, but it's right outside the courthouse when they're walking out. They're not making the affirmative effort to pick up the phone and give me a call. That's a different thing.
So the only times I've ever had people or jurors reach out to me is when I won, never on a loss. Yeah. Right. I mean, just that's just how it's gone so far. I don't know if that's how it is for everybody. Okay. So, they talked to 3 of the 12 jurors. Undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors. So that might be a little bit of a stretch, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in 2nd degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent that the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize the defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone.
Okay. We have to go back a little bit. The reason he put in so many words, so many adjectives, emphatic, the absolute cast in stone, not guilty, is because, when they did their research, they found, and we've talked about, case law that says that if it's not cast in stone, emphatic, and still wavering and vacillating, that it is not a verdict. So they had to put that language in there in order to get further on in this motion.
Jojo, I see people asking about the document. This is the best I can do. I wasn't sent like the cleanest of versions, and I've been in other meetings and stuff all day. I haven't actually been able to go to the docket. So all this stuff is kind of sent to me PDF. So we're going to do the best we can, but we are going to read every single word so you won't miss anything. From my perspective, there's a lot to be learned by these comments. And they're going to dig into them a little bit more as the motion goes on. So I'm going to hold some of my thoughts until we read exactly what happened on these 3 charges and why it happened this way. So first, background. On June 9th, 2022, Ms. Reed was charged via 3 separate indictments with murder in violation of this statute, vehicular manslaughter, and leaving the scene of a personal injury or death in violation of this. A jury trial began on April 16, 2024. July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. So what's interesting to me is I have never had a case ever in my life, never had a trial where there's a jury question. The court did not allow us to read it immediately. It's the first thing they do when they call us in the courtroom. Have you ever had that?
No.
So that's wild that the court got a note. I guess maybe everybody, just like we all watching, assumed we all knew what it said. But the fact that the lawyers didn't see it is kind of wild to me. Okay, in short, neither defense counsel nor the defendant consented to the mistrial. And the court never ascertained from the jury whether its deadlock was in relation to one, two, or all of the charges in the indictments. So I have some thoughts there. So we're going to pause there for a second. And I want to show you this, because here's my thought. And I know your kind of feelings overall on this motion and kind of, how much, what the teeth of it is. But let me just show you the verdict slip, okay? And we talked about this a little bit already, and I showed you these, and we talked about, the different boxes. But if the jury went through these verdict slips and they were unanimous, not guilty, on count 1 and count 3, what is to stop them from checking the box not guilty here that we're looking at on count 1, and then skipping over count 2, which by all intents and purposes seems where they hung, and then clicking not guilty here as well? The big discussion was whether or not there should be not guilty boxes on all these lesser includeds. I've seen a lot of that on Twitter today. This is exactly what we knew was going to happen because the way the verdict form was set up, but not really, right? Not really, because there was the opportunity and the way on the verdict form, which they said they understood, to check not guilty on counts 1 and 3. So how does that affect your analysis? And if you're the prosecutor arguing that this should be hung on all 3 charges, how does this affect your analysis? That they could have checked not guilty?
Well, it's the argument that it still wasn't a final verdict. Is that what you're going for? Because and that's the way I'm.
In my opinion,
it's not a final verdict. They didn't check the box.
Well, not only was it not a final verdict because they didn't check the box, but they can say whatever they want now. At the time, they had these papers in front of them, and they didn't check not guilty. They very clearly could have. Nothing stopped them from checking not guilty. They never asked the court, hey, we want to check not guilty. Can we check not guilty? What could have been going on was some kind of, and again, here's some of the questions that are coming in with the different boxes, but I don't think that would have affected this. But it could have been some discussion about splitting the baby where they're saying, okay, fine, we'll agree not guilty on count 1, but let's really talk about count 2. And they never really did an official vote. Now, that's all speculation. They absolutely could have come to a full vote and just not known that they could have checked the not guilty box. That's absolutely a possibility.
Well, and I think it's logical. It's logical. I mean, you think about it. We're not going back in the courtroom yet. So let's sit here and still talk about it, because this is the 4-person's responsibility. And the 4-person probably said, I'm not going to do this till the end. And that makes sense.
Right. I agree. Or maybe it was a straw poll. They didn't really, discuss it that much. They went through it kind of quick. Nobody kind of felt that one. Let's go to count 2. But they didn't dig into it enough to feel like it was a final verdict like we talked about. And we'll talk about why that's so important. But from my perspective, when Yanetti and Jackson, the defense lawyers, are asking for potentially the judge to call the jury in and ask them, that's a way we could resolve this ambiguity, right? That's a way we could fix this problem. That's a way we could actually get to the answers that right now we just don't know. There are arguments on both sides. There are arguments on the side of it is a hung jury and a mistrial in all 3 because they didn't check the box. But there's also a side where they all agreed 12-0 that it should be not guilty. So why should we retry somebody when double jeopardy should attach?
Yeah, it's a shame that the judge dropped the ball. He really should have asked, when they came back hung, he should have asked them, is that on all charges?
It's a she, but yeah, I agree.
Yeah,
I think that she definitely dropped the ball on that. Another thing that's interesting to me, okay, when you look at this verdict form, so you see count 1 and count 3, these are the 2 counts. People are asking, how is it possible if the jury's 12-0 on count 1 and 3, but not count 2? Well, it's kind of like we talked about the whole time. There are two main questions. And when I say we, I mean me and the chat. I've been talking about this the whole time. There were two main questions in this case. Was John O'Keefe hit by a car? Because if he wasn't, it's not guilty across the board. But if you think he was or may have been hit by a car, you have to continue the discussion. And point number 2 is, did she know? Did she do it on purpose? Did she leave on purpose? And if you think the answer is no to that there's no intent, she didn't intend to harm him, she didn't intend to leave him there, then counts 1 and 3 are not guilty. But if it was an accident and she may have done it and not known it and left him to die there in the cold, count 2 is still on the table. So it seems like, and do you agree that with that kind of logical step using common sense, that's kind of how, if they voted 12-0 not guilty on counts 1 and 3, that's how they could still be discussing count 2, but that they probably felt like, at least some of the jurors felt like he was hit by a car.
Well, again, it's been a while. I've decided I never can guess what a juror is thinking.
Sure.
And because, sometimes they see evidence that you never saw when they take it back in that jury room, or, some testimony affected them like you never thought it would affect them. The prediction and trying to see what they thought. And I've had inconsistent verdicts. I've had people be found guilty of something and not guilty of another, where I come back and I say to myself, well, if he's guilty on that one, he has to be guilty on the other one. How could you say guilty on one and not guilty on the other? It could be there's compromises going on in that room as well, where people are saying, all right, not guilty is on 1 and 3 if we find him guilty on 2. They can do that. And they could be thinking that way. So it's very hard to predict how a juror is thinking.
Right. But I think that if what's in these affidavits is true, it is indicative that at least some of them think he got hit by a car. I mean, yes. I don't understand how you get there, even in the manslaughter, if, like, from my perspective, when I listen to that evidence and that testimony and the experts, I don't feel like the state ever proved he got hit by a car. And that's not how this jury felt, which is, right. That's the interesting part. And that's what's coming out in this affidavit that is not necessarily good for Karen Reed and her team and the new trial that, some people thought was a slam dunk or a guarantee, or a lot of people in the media world saw it a certain way, but the jurors don't always see it the way the media does. A lot of times they do, but not always.
And this is great for the prosecution, because if they're going to retry this case, then they've got a little heads up here. You know what? We did a good job of proving that. Now we got to work a little bit more on proving the other elements of the case. So this really helps the prosecution when they retry this case.
Potentially. I mean, it's a new jury. So they have their own set of circumstances and unknowns that it's hard to guess, right?
It is. But if I was a prosecutor, I'd look at this and I'd say to myself, we did a good job on that part.
You didn't watch the whole trial. I don't think they did a really great job on that.
Some jurors believed them.
Yeah, exactly. They believed it, but I'm not sure it was because of the prosecutors. Okay. On the following day, on July 2nd, Attorney Jackson was contacted by a juror.
I'm going to get a glass of water. I'll be right back.
Okay. The following day, on July 2nd, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that she/he wished to inform him of the true results of the jury's deliberations. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1. Juror A was emphatic that count second-degree murder was off the table, and that all 12 jurors were in agreement that she was not guilty of such a crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene of the accident with injury or death. Another day later, on July 3rd, Attorney Yanetti was contacted by 2 different individuals, and this is an important distinction. Individuals, not jurors. Informant B and Informant C, who received information from 2 distinct jurors. So these are basically people that are either friends with or connected to jurors directly, but not the jurors directly. Both of whom were so the jurors that they had contact with were part of the deliberating jury. They sent Yanetti screenshots that he or she had received from someone of text message that intermediary B had received from juror B. So it's like 3 degrees of separation. Juror B sent it to the intermediary, who sent it to the informant, who sent it to Yanetti. Okay, hopefully you're tracking. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. It says like there was maybe a issue there. Maybe they just said hit him at all. I don't know. Informant C had been in contact with another individual who is a coworker and friend of Juror C and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent attorney Yanetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the meeting. No consideration of murder 2. Manslaughter started polling at 6-6, so it was tied. But then it deadlocked at 4 no and 8 yes, which I read to mean 4 not guilty and 8 guilty for the manslaughter count 2, which is very interesting, which means if you remember back, it felt to me like the state was pushing to keep this jury deliberating. And the defense wanted to say there was due and thorough deliberations, wanted to read them the Tui Rodriguez or Allen charge, as you know it, and the state did not. The state wanted to keep pushing them. And I don't know how. I don't know how the state maybe had some indication, or they felt like they knew the jury, or they felt like they were winning, but it went from 6-6 to 8-4. So maybe if the judge would have kept pushing them, it would have kept going in that direction. Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip. That was all confusing. The jury verdict slip, that was all confusing. Now, if we want to talk about a confusing part, maybe count 2. Did you feel like counts 1 or 3 were very confusing?
No, I don't.
Lastly, she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. So the confusing charge is what they were hung on, not necessarily the 2 that they found that she was not guilty,
right.
But then they didn't fill it out, which comes back to what did the jury know or not know that they could do with that verdict slip? And I could understand how they just didn't think that they could check the not guilty box. I know how a prosecutor may argue, which I talked about earlier in the video. If I was the prosecutor, I would argue they didn't check it. But as we know, jurors have never done this before. This is kind of their first crack at something that's very important and nerve-wracking. Some of them have been on other juries, but you get what I'm saying. So what do you take from those text messages from intermediary or informant C?
Well, you heard the jury, the jury instructions that they get and what they're told to do. Jury instructions are confusing by nature. I mean, they just are. I don't know how many pages of jury instructions. Do you know? Did they get?
I can't remember. It was a normal amount. It wasn't a crazy amount in this case.
20 or 30 pages?
Probably.
Yeah. They're confusing and they're also conflicting. Sometimes they'll say something in one part of the jury instruction that sounds like it's conflicting in another. I can see how they're confused. But I got to be honest with you, again, if you believe what's in the affidavits, there really wasn't confusion. They found not guilty on 1 and not guilty on 3. They were hung up on 2. And when they went back after what we call, again, the Allen charge, after they went back, they voted again and it became 4-6. So 2 people apparently were not so confused that they couldn't change their vote. This is normal jury stuff. This happens in jury rooms all the time where the votes change, the votes swing. So I'm not really shocked by the fact that the voting changed on 2, but stayed firm on 1 and 3. That's a normal occurrence.
All right. So next is the argument. The jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. So if that is what happened, just by that title, then the defense is unequivocally correct and right. But is that what happened? And that's what they have to prove. And that's where the argument comes in. What constitutes an acquittal is not to be controlled by the form of the action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. The mere presence of absence of check marks on a form is not dispositive. And while they're correct, it certainly would help in a situation like this, right? It certainly would help. Here, the attached affidavits by Attorney Jackson and Yanetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. Okay, and then they reference the affidavits again, reflecting text messages, what they said. No one thought she hit him on purpose. We're going to read those affidavits in their entirety. To hold that this firm conclusion did not amount to an acquittal is simply because it was not recorded in a verdict form would be to elevate the form over substance in a manner prohibited by the foregoing United States Supreme Court and Supreme Judicial Court precedents. The Supreme Court's decision in Bluford, that's the case I mentioned earlier, is not to the contrary. So this is interesting. Before the state has even responded by doing their research and citing cases like Bluford, the defense is already going on the offensive here and saying and differentiating this from the case they know that they're going to cite, right?
Well, and they're also, notice the way that they refer to the other two jurors who they did not, they have basically hearsay, secondhand. They refer to those as actual statements by actual jurors. And we know they're not. We know that somebody told them what somebody else said. But, you know, they're being a little strong in the way they're wording the three jurors.
Which is not surprising from what we've kind of heard throughout this process. They're going to use what they've got. They're going to call it Bible and gospel as much as they can, whether or not it is, right? And I think that's for us. Again, somebody who thinks Karen Reed is not guilty based on how the evidence was presented in that trial. Okay, I'm firmly there. That's what I believe was presented. But we got to shoot straight. We got to see it and call it how we see it. And it's a way of using information. And that's the way that they are using information in this case. But I will say at the same time, as we mentioned off the top, this is information you don't often get. And with screenshots and direct connections, and they had the ability to confirm the identity of which jurors these people were talking about, it is a lot more than nothing. It's not quite three jurors calling them directly and getting their statements directly, but it's one plus two, you know, with a couple degrees of separation. So it's still a lot more than you have in your average case. That's for sure. The Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charge of capital murder and first-degree murder, but split on manslaughter. So this case, just a little background, they actually came to a decision on first degree, but they couldn't come to an agreement on manslaughter. Imagine if that would have happened in this case, how the media would have reacted, how everybody would have reacted if that's happened. We didn't even get that far. As far as we know, which we didn't read all the juror notes and we don't know what was said behind closed doors, but they never even came to a unanimous decision that was reported to the court or the lawyers that we know right now. So this case took it even a step further than what we had from this jury, where they let the court know that the jury was unanimously against the superior charge. The court sent the jury back to continue deliberations on manslaughter. When the jury remained unable to reach a verdict, the court declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. So the defense made a similar argument in this case that because the jury said they were unanimously against the superior charge, the state should not be able to bring it, even though they didn't fill out the verdict form for that. Supreme Court said, no, the state is allowed to go for that first degree again on the second trial. In doing so, the court relied heavily upon the lack of finality of the jurors' reports. The jury deliberations had not yet concluded, and it went back to the jury room to deliberate further. Here, by contrast, the jurors' statements reflect a final determination that persisted throughout the end of deliberations. So what they're arguing here is those three juror statements, not the 12, not the jury as a whole, which is what the Supreme Court was looking at in the Bluford case. But Yanetti is saying these three jurors in this case are saying unequivocally that's how it ended. I know people are going to say, let your dad talk. You're talking the whole time. It's because I'm reading 10 pages of documents. And you pipe in whenever you want or have something to say. Do you have anything right now before I keep reading?
No, I really don't. It's again, just everybody keep in mind, it really isn't three jurors that have said this to these lawyers. It's one juror and two people who were informants or intermediaries, however you want to call it. And, you know, they're using this saying there's three jurors have said it, three jurors have said it. It's not as strong as that. And so keep that in mind when you're reading these cases.
But you told me before the video before we started on the record, that you do feel like this is enough to at least get the ball rolling on something.
Oh, absolutely. And as he asked for the remedial things that he wants the judge to do, and when we get down to that, there's one of them that I absolutely agree with, and I don't see how the judge can deny it.
And that's because of this information that they have, even though it's not exactly, verbatim first person from 3 jurors. That's what you're basing it on.
Well, actually, I'm basing it on the one, because if they didn't have the one direct guy, and they just had 2 guys, I heard somebody say, I don't know if the judge would have to grant them that interviews of the jurors. But because they have the one that they did face-to-face,
let's not spoil it. Don't jump ahead. Because you're already starting to jump ahead. All right, let's hold it till we get there, because I agree with you. I just want to make sure you didn't have anything that I missed while I was just continuing to read here.
No.
Okay. Where was I? The jury's deliberation concluded. They went back. Okay, even assuming arguendo, and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford a broader protection under Massachusetts state law. Unlike the United States Constitution, Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and protections. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was unanimously agreed. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for this mistrial. Here, Ms. Reed did not consent to the declaration of a mistrial. In this case, they rejected the argument that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed.
All right, let me just want to point out.
Go ahead.
And first of all, let me say, I would file this motion just like these defense lawyers did, and I would protect my record, and I'd make sure I had the record for appeal. So I would make all these allegations. But if you look at B is a leap. Re-prosecute independently barred because there was no manifest necessity to declare a mistrial on counts which the jury was unanimously agreed. Well, first off, that's still an issue. That's an unproven fact that they unanimously agreed to this. So asking for B before there's any evidence presented to a judge that there was unanimous, that's a leap of faith. And that's inserting a fact that hasn't been proven yet. Although I would say it too. I gotta admit.
They're not going to win on this. I could just spoiler alert for anybody watching. They're not going to win on B. A is much more interesting, but saying that they did not consent to the mistrial after multiple hung jury attempts, after she read the Tui Rodriguez instruction, after the defense agreed that there had been due and thorough deliberations and asked her to read the Tui Rodriguez instruction, knowing what would come next, I don't find it, just in my opinion, a very strong argument here for B. Now, what's interesting is I don't understand how they didn't see this jury note or the jury question. And if there was some indication in any of these jury notes that they didn't get to see, that may have said they were unanimous on one of the charges, that creates a totally different situation. I assume he would have seen it in this motion if it existed. But, just from what we know, I don't think this is their strongest argument. But again, they're protecting the record here.
Did you watch the verdict come in?
Yeah.
Did
the mistrial? You mean the hung?
Yes.
Yeah.
Did you see any lawyers stand up and try to say something?
I don't remember, but I know that they multiple times interrupted her to make their argument. They were both very skilled, very competent, very confident lawyers who controlled that courtroom. They spoke when they wanted to. She would try to cut them off sometimes. They would continue to press to correct or to make sure the record was correct. So I think if they wanted to say something, they would have got it on the record. That's just my opinion. That doesn't mean that the judge shouldn't still allow them to if it's absolutely necessary.
Oh, right. But I just can't see, like I said, if I'm in a courtroom and there's something I want to say, the judge doesn't scare me, and I don't think that these guys were scared of the judge either.
No.
They should have stood up and said something if they wanted to, this question asked. But I wonder why they didn't.
I just don't think that they were objecting to the mistrial. It was hugs and kisses and smiles at the end for the defense after the mistrial. And again, for defense attorneys, the mistrial is kind of a win because the state failed their burden. They failed to unanimously prove the defendant was guilty beyond a reasonable doubt. So I get that.
They got lost in the moment. They got lost in the moment, is what you're saying, right?
So I don't know if they got lost in the moment, but I think that it would be hard for me to understand them blowing an argument. And there's a fine line between not making a timely argument as a lawyer and therefore waiving it, right? We all know that. We all know that you can waive all sorts of arguments by not making it. And to say the judge did not provide you the opportunity to be heard. She declared the mistrial, then brought the jury in to actually declare the mistrial, right? She said she was going to declare the mistrial. So there was an opportunity before the jury came in that if any lawyers really want to stand up and pound the table or do something else, they did have the chance to do that. Now, whether or not they're going to say they felt like based on her demeanor and actions that they couldn't have, I don't know. That would be interesting. But these lawyers were on the ball and made every argument that everybody's saying she swiftly made the mistrial. I get it, guys. And you also know plenty of times she tried to shut them down. She made adverse rulings to them. Sometimes she was totally on the side of the Commonwealth, it felt, and they still pushed through. They still made the arguments they wanted to, as they should. They were very competent and confident, like I said. Okay, so let's continue here. I know people are not going to be happy with us just not saying everything the defense did was perfect and amazing and is going to win. But again, that's the point of reading these documents and just trying to break it down. Okay. Let me see where we are. Okay, absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of a defendant whose initial trial ends without a conviction. This rule is rooted in the importance of the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. So here's another thing, which how does this play in? The jury came back multiple times deadlocked, and she gave both sides multiple opportunities to be heard. And never in those discussions did the defense ask for an instruction or a question about individual counts, about polling the jury. That was never a request made. And I think it was 2 times that the jury came back as deadlocked. So that would have been an opportunity to ask about, individual charges, right?
Yes. Or one of the opportunities, yes.
Right. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected. I mean, okay, we did videos every single day the jury was out. We did videos when the jury came back deadlocked multiple times. And what did we expect the entire time? That there was going to be a mistrial. Whether it was after the first, after the second, after the third, or maximum, maybe they could have sent them away one more time. So I just don't think that it was unexpected. That's just my opinion. Nor accompanied by discussion with counsel. And then they cite some cases with no manifest necessity where no opportunity was given counsel to argue the propriety of the question of the necessity of a mistrial, finding no manifest necessity where the trial judge first ruled that he was going to declare a mistrial and then, almost as an afterthought, unenthusiastically asked whether counsel objected. The record is independently lacking on the second prong, as it reflects to no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative to simply ask the jury to specify the charges on which it was deadlocked. Had the court done so, and the jury articulated its verdict consistent with the statement of jurors A, B, and C, the double jeopardy implication would have been clear and decisive. Indeed, with virtual unanimity, the case the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury reached an agreement. Nobody's going to argue with that. The Supreme Judicial Court's holding in Commonwealth v. Ross that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As the Roth Court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separated charges carries a significant potential for coercion. Declining to require the court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses where under Arkansas law, the jury's options were limited to two, either convict on one offense or acquit on all. Such inquiry, which again, that calls into an interesting discussion on the verdict slip, which we're not going to get into again. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here, the jury was asked to return three separate verdicts on three separate counts, distinguishing situation where a defendant has been charged in three separate indictments or complaints, each with a separate verdict slip. In this circumstance, whether the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straightforward and the defense contends constitutionally required follow-up question to ask whether the deadlock relates to some as opposed to all the counts. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite the deadlock on the other counts. I think that's a really well-written and argued argument. Well-researched, makes perfect sense, and I completely agree with it. Now, it's all on a premise that is still yet to be proven, but I do agree with him there that that is a differentiation. Don't you agree?
Yes. Oh, no, he did a good job.
Alternatively, the defense is at least entitled to conduct post-verdict inquiry. All right, here we go. So we're going to read it, and I know this is where you have a lot of your thoughts. Undersigned counsel did not initiate the communications with jurors A, B, and C, which resulted in the disclosure of information that is memorialized in counsel's affidavit that are appended to this motion, which we're going to read. Should this court find that further factual development is required, which is exactly kind of what we've been talking about here, the defense respectfully requests that the court conduct a voir dire of the jury or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek an affidavit of each juror, example jurors A, B, and C, the defendant asked the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty on counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted in the present context. Just as the court in McCallop approved questions as to the existence of racial bias, questions about a matter more attenuated from the content of deliberations, whether the jury had unanimously concluded that Ms. Reed was not guilty on counts 1 and 3, do not invade the heartland of the jury's deliberation, but preserve the defendant's precious rights to the favorable outcome of a jury trial and to the protections of the double jeopardy clause and its related state judicial protections. In conclusion, for the foregoing reasons, Ms. Reed respectfully requests the Honorable Court to issue an order dismissing counts 1 and 3. So talk about now your thoughts, and I've got a lot of thoughts as well, about a potential post-verdict inquiry, either by the court basically questioning the jurors or the defense being able to reach out to them and talk to them.
Well, first off, the only thing this motion should have asked for is C. It should have been based on getting C, because when you get C, then if you are successful in C and successful with those interviews, then you talk about dismissing the case or dismissing the counts or double jeopardy. But until that happens, you can't ask for those other things. So I really think it was a waste of paper for him to go through all that. Rather, he should have asked for C and said, and conditionally, if we are successful in C, and if we prove this fact, then the court is going to have to do A and B. So I really think that they watered down their argument, and they should have just concentrated on doing C and just asked the judge for C. It is the least offensive to the judge in that the judge could say, okay, I'll do a voir dire and I'll just ask them that question. That's number one. Number two, C is also the most logical and the one they have the best evidence of, because they have one juror that's actually said it and they've actually talked to. The other two are kind of weak. The other two are informants or intermediaries. And we've never heard, why don't those other two jurors come forward if they wanted to say something? But they haven't. If he didn't have the juror that actually spoke to him, then the judge would have a real easy time dismissing this and getting rid of it, and I think he'd be upheld. But because he has that one that he actually spoke to, and now the other two do kind of back him up, he's got some credibility there, I think that the judge should do C, and should do C in camera with each juror and questioning the juror on their verdict. I don't know if he should do it in front of all the lawyers, because I certainly wouldn't want, again, the intimidation factor you're talking about. But then again, on the other side, I don't know if he can do it without the lawyers. Legally, he may have to have the lawyers in there when he's doing the voir dire to get to the truth. So
a bunch of people are putting out there that the juror instructions were very confusing and complicated to them too, and they may have messed it up. So I do understand that. I just think when it comes to this, and we talked about it in the Maya case as well, and in the Ghislaine Maxwell case, where we talk about when something like this happens, and it is this important, why not, in the interest of justice, try to get the truth? And I'll take it a step further as to what should happen, regardless of what the judge does. If I was the prosecutor on this case, I would want to know. So I would try to, if the judge would allow me, I would try to reach out to juror A or some of the other jurors, or maybe all the jurors. And if they told me they all would have voted not guilty in the pursuit of justice and truth, I would not retry those charges. I would dismiss counts 1 and 3. And if they were really hung on 2 and I wanted to go forward on them, that's within the prosecutorial discretion. And that's something that they can make the decision on. It's their prerogative. But they should also want to know this answer. Everybody, the judge should want to know this answer. Everybody should want to know if this jury, and by the way, when you have a mistrial in a situation like this with a hung jury, this was your jury. This was your one shot and your one swing. So if they made a decision on some of the counts, that should absolutely rule the day, and it should be over on those counts. I don't think anybody is going to disagree with that. Jay Michael said, how does the Massachusetts rule that 3 notes equal mistrial without consent play into this? So technically, based on what we read, the judge could have potentially sent them back one more time before she got to the max. I highly doubt that's what the defense would have asked. They're not even saying that's what they would have asked. They're saying they would have asked, are you deadlocked on all 3 charges, or something to that effect. Adrian said, Massachusetts doesn't poll juries. They did ask for the form to be made clearer. Yanetti even said he never seen a form like that, but it really wasn't on counts 1 and 3. It was focused on count 2. Just Call Me Megan said, stupid question. Could they have rotated in alternates to get over the deadlock? No. The jury that's picked, the jury that sat there, that's the jury to make the decision. The alternate would not have come in unless a juror got sick or couldn't go forward. So additionally speaking, I think based on juror number 1 and even what they got out of, or juror A, I should say, and even what they got on from jurors B and C, that's enough there for the judge to inquire further. One thing I'd be worried about, and something I might object to if I'm the Commonwealth, maybe if I'm the defense, is influence, coercion, intimidation, how much connection the jurors have gotten to the media, to Twitter, on what everybody's feeling out there. It's diabolical out there, folks. Trust me. I know. I get it. I hear it from both sides. Nowadays, more one side than the other, but after this video, we'll see. People struggle to have open conversations about this case, and I understand. As I've said from the jump, there's a lot of passion behind it. But how do you think a judge, and somebody on here said, Dad, you should consider being a judge. I always make jokes how we would, I don't think we'd be good judges. We'd also never want to be judges. But how would you deal with media influence, potential coercion? How can we make sure that's not a problem if we're going to ask the jurors questions and bring them in and see what the votes, quote unquote, would have been at the time?
Well, first off, I think you and the judges aren't stupid. you'd be foolish to think that if you're a juror out there, you haven't read this motion or you haven't seen. In fact, I read some of the news or the media, and again, the mainstream media even, about this, and it's reported all over Boston. So you can't possibly, as a juror, not know. You know you're going to be interested. You sat on that case. Oh, something happened with the jury. You're going to listen to it. So the jurors know that this is going on. So you got that number one issue you've got to deal with. If I'm a judge and I bring them in, I tell them that, look, I understand you may have talked, you may have seen something in the media, but I have a simple question for you. And it's only one question. And or two, because there's two counts. He would ask those two questions and nothing else. And the other question he might ask if he wanted to get into it, how firm was your vote on that not guilty? Because we all know that they could have maybe said not guilty, but jurors are allowed to change their mind in that jury room. They could vote not guilty 1 hour and guilty the next hour. So it has to be a firm not guilty that they were not going to change, and there was no need for additional deliberations on those counts. That's what the judge has to find out. He can't help. You can't help it. These people have read this stuff. They've been tainted. So you just got to deal with it. Deal with it.
One of the things, just so people don't get confused, when you were saying he's going to ask these questions and he's
I'm sorry, she.
I just want to make sure people are not confused when he's saying
sorry,
that.
You're right. She.
I
didn't watch a lot of the trials, so I did. So she.
Right, but what I'm saying is he's just talking like judge in general. These are the types of questions that a judge would ask, and I do agree with that, and that's a good point that you bring up. It would be limited to just, would you have voted not guilty on count 1? Would you have voted not guilty on count 3? Whatever it may have been. I don't even know if it would be a proper question where at the time, was it unanimous 12-0, or if you just ask individual jurors what your vote would have been at the time, and not even like, is it still the same today? That question would not be relevant because, again, any information they would have gotten after the deliberations would not be relevant. So it's just kind of interesting to bounce that around.
No. They might ask the jury if it was your understanding that the jury had reached a unanimous verdict on that count. Each juror, you might want to ask the jurors that if they felt that that count had been deliberated, voted not guilty, and they were moving on.
Yeah, I like that kind of phrasing it like that because, again, it relates back to at that time.
Right.
Tobin said, I missed it. How did they know the jury votes on counts? So they talked to one of the jurors, and then they talked to intermediaries with 2 other jurors who gave them those breakdowns. John, they can't review the trial again. Did I understand that correctly? Yeah, they're not going to go back and re-go over the evidence and redo their vote. It's really what happened in the jury room at that time. Michelle, I was curious, why didn't the defense request the poll? The jury, does that hurt them now, or is it not allowed in Massachusetts? Not allowed in Massachusetts. Is it allowed here? I've never seen a jury polled during when they're in the middle of a deadlock in a criminal case.
No. They don't get polled then. But the judge does normally ask if it's on all counts.
Did Bev hide this info? I don't think we have any information that would say that at this point. We would need more info to say that. Can the defense put the judge on the stand? Somebody else asked. Could Bev, who's the judge, be a potential witness? I don't see how she would be a witness unless they find some wrongdoing, like she talked to the jury in some back room and told them to do something. But based on what I've seen, I don't see her being a witness. Do you?
No.
I have not seen a date for this motion to be heard yet. Nina, why didn't the judge ask the foreperson if the jury was hung on all charges unanimous on some and then dismiss those charges? That's kind of within judicial discretion, right? I mean, do you think that's automatically some kind of error that's going to create a dismissal situation? Or
well, I read the rule, and the rule says may. The judge has discretion to ask that question.
When he says the rule says may, he means the judge may or may not do that. If the rule says shall, it means the judge has to do that. So when he says may, my dad, that's what he means. Is this because they didn't have anywhere on the verdict form to check off not guilty on each charge? So no, Jillian, that's why I showed the verdict slips on those 2 charges so everybody could understand. Can we please talk about the letter sunnied by the jury, read by the judge, plus this? I'm not sure what that means, Megan. Teresa, do we actually know how the juror form was filled out or not? Have we seen the forms? No. I would assume by this, Dad, and you tell me reading between the lines, I would assume it wasn't filled out at all.
Yeah,
the
I'm
verdict.
almost sure it's a big blank. Yeah.
Why didn't they poll the jury? It's not proper in Massachusetts. It's just not something you do. It could potentially create. I also read somewhere, maybe it's in the affidavit that we're going to get to, that like bullying started once the judge started sending them back. Is it the judge's responsibility to be the ref of the facts, black and white? Why all the gray area with her / the prosecution? It feels interesting / intentional. She's the gatekeeper of what goes to the jury. She's not really like telling them what the facts mean. They've got to determine what the facts mean and what they point to. All right. Isn't it all or nothing when they don't have lesser included? So no, each count is individual, Rebecca. Each count is individual. They could have come not guilty, guilty, not guilty. They could have had different answers on each count. Does this make Yanetti and Jackson witnesses now? Is that why they appointed that additional attorney? So I haven't had a chance to look into the additional attorney. I have heard that the
Marty Weinberg. He's older than I am.
Oh, so you know who he is?
Yes, I do.
Okay, and is he an appellate attorney? That's what I was thinking.
No, he's a really good criminal trial lawyer in Boston, and like I said, he's been practicing for a very, very long time. Years ago, he probably won't remember it. Years ago, we had a case against each other in Orlando.
And?
Well, his client pled guilty. So
you
never actually went to trial. I was a prosecutor. We never actually went to trial.
Okay. All right. See, even good criminal defense attorneys can't change the facts.
That's right.
Okay.
He's an excellent criminal defense lawyer.
All right. I'm going to do my best on these. Some of it's blurry, some of it's not. So let's take a look and read these affidavits now that are in support of that motion to dismiss. Let's see. Can I make it any bigger by doing this? Yeah, there we go. All right. I, Alan Jackson, declare I am a partner at the Los Angeles law firm of Worksman, Jackson, and Quinn, and I have been licensed to practice law since 1994. I'm counsel for Karen Reed, appearing on her behalf. On Tuesday, July 2nd, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Based on my conversation with Juror A and that juror's description of who he or she is, where he or she was seated, and certain identifying information, name, occupation, disclosed during the voir dire process, I was able to positively identify the juror, which juror he or she was. Juror A told me that he or she was seeing inaccurate reports about the split. Okay, just that right there. Seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. That right there indicates they're watching the media, they're seeing, they're following what's going on in the case. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that she believes it important to disclose such results because she believes that those results significantly impacted Ms. Reed's rights. Juror A told me that the result of the deliberations was the jury unanimously agreed that Karen Reed is not guilty of count 1. Juror A was emphatic that count 1 was off the table and that all 12 jurors were in agreement that she was not guilty of such a crime. You repeated it like 6 times just to make sure the judge understands. No question, not guilty of the crime. Juror A told me shortly following that determination regarding count 1, the juror also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. On July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review, which I think is crazy. Rather, the court indicated the jury was at an impasse. Once the jury was seated, again, there was time between jury's at an impasse, judge brings jury in, where they potentially, arguably, could have made an argument. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. Did they object? I don't think they objected either, which is interesting as well.
No, they were silent according to their own motion.
And they put in there that case that says just because you're silent doesn't mean you have the opportunity to be heard. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court inquired, it appears clearly that not guilty verdicts would have been recorded for counts 1 and 3. Ms. Reed was denied her right to receive those verdicts in her favor. The foregoing is true and correct to the best of my knowledge and belief under penalty of perjury under the laws of the United States, the state of California, and the Commonwealth of Massachusetts. So explain for a second why you sounds like you have a comment, but also explain why lawyers have to file affidavits like this and why it's so important and usually taken as trustworthy, especially in light of that last paragraph.
Well, you have to file the affidavit because there has to be some factual basis for anything. So if the judge is going to do something, he's got to have some facts to do it on. An appellate court's going to look at this motion and say, where's your facts? Nothing was established. So we have facts. Secondly, now we have facts, so the facts have to be either proven or disputed at a hearing. So it establishes the facts. The other thing that I was going to say, and I know you've said it before, but I try cases all over the country, state and federal court, and they always have notes from jurors. Never in a million years have I ever seen a judge not call the lawyers up to the bench ahead of time, show them the note, and ask them, well, what do you think? Do you have any comments about the notes? I've never had that happen. This is really surprising to me. That, again, I don't know if there's a rule that requires it, but it surprises me that her protocol was such that she didn't do this to these lawyers. But regardless, she didn't. And they should have said something that they didn't. But you have to have an affidavit. You got to have facts. You got to have facts you say you can prove, and then you have a hearing. At least I hope they have a hearing.
And that's why a lot of people like Kevin's asking, the judge, Yanetti, Jackson are all now witnesses. The new attorney filed this. I think because they see an affidavit, because they see a new attorney, they automatically think everybody's now a witness. That's not really how it works.
No, it really isn't. These jurors are the witnesses, these lawyers, because it doesn't prove anything that a juror told a lawyer this. The juror has to say it themselves in court, under oath, on the record.
Nina said, isn't it better for the judge to know if the jury wasn't hung on all charges? You would think. I mean, you would think everybody would want to know this. Like, we're fighting for the truth and for justice here.
What I read, 65 witnesses in this case, something like that?
So I think it was 68, but yeah.
68 witnesses? Who wants to go through a trial with 68 witnesses again if you don't have to? Even the judge.
Brooklyn Basement said, aren't screenshots of the juror's text first person, though? Let's get into Yanetti's affidavit now and see whether or not we feel like it's first person, if those screenshots are with the jurors, et cetera, et cetera. Here we go. Yanetti time. Let me try to zoom in some. Okay. I, David R. Yanetti, do hereby depose and state that the following is true to the best of my knowledge and belief. I am an attorney licensed in Massachusetts. Okay. July 3rd, I received communication from two different individuals, hereinafter informant B and informant C, who received information from two distinct jurors, both of whom were part of the deliberating jury. To my knowledge, informant B and informant C do not know each other. On July 3rd, informant B sent me a screenshot he or she received from intermediary B, okay? Not from juror B, okay? So the screenshots of text messages were not from juror B. Of text messages that intermediary B had received from juror B. In that screenshot, maybe it was, okay, maybe it was. Maybe it was a screenshot of a screenshot. Intermediary B had a screenshot with juror B and sent that to informant B, so therefore it would have been somewhat directly from juror B.
Wait. Excuse me. Let me see if I understand that. So, juror sent a screenshot or sent an email to somebody.
Screenshot text message.
And then that somebody gave it to somebody else, who then gave it to the lawyer.
Yes, it seems like I am texting with mom. Mom says something. I screenshot me and mom's text and I send it to you. So I'm sending you a screenshot, but it's of some, or no, actually, it would be even one removed from that.
Right.
It would be a screenshot of mom talking to somebody else that somebody sends to me and then I send to you.
So this is double hearsay.
Yes, exactly. But, we'll see. We'll see, especially if they can confirm that that's the person's phone here. It was not guilty on second degree and split in half for the second charge. When the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case, No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. So it turned into a bully match, which I don't think is great. But this is kind of what they're kind of describing the scene, and they describe it even a little bit more. Based upon the first name of Juror B given to me, I confirmed that she was deliberating juror. On July 3rd, the informant C contacted me to say that he or she personally knows Juror C. They used to work together, and they have a mutual friend, Intermediary C. So both of these are through intermediaries. And I'll just tell you, okay? These are the actual lawyers on the case, big shots, people reaching out, all that. I have had multiple people reach out to me on multiple cases saying that they are a friend of somebody involved in the case, and they have this email and they have this screenshot. It is very difficult to authenticate. I usually am like, I don't want to take the chance that this is fake, and I don't really get involved and don't really get into it. But when it affects your client's rights like it does for these lawyers, they did the extra steps to confirm that these jurors are actually jurors on the case. So they took the steps necessary to try to confirm that. Informant C told me that she had posted something about Karen Reed on Facebook. He or she told me that he or she believes the post led Intermediary C to text him and inform him that Juror C was a deliberating juror on the case. Informant C told me that he or she thereafter reached out to Juror C via text and discussed his or her experience as a juror in very general terms. They discussed what an exhausting experience it was and that Juror C was relieved it was finally over. Intermediary C told Informant C that Juror C would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. So that's interesting. Even more of an indication that there's discussions, people watching stuff, people seeing stuff on Facebook and other social media. So the jurors are getting outside influence in this point. Not to say it would change their opinion, but it is happening, and it is something the judge has to consider, don't you think?
Yeah, well, you know what else? If you really, read between the lines here, Informant C may not be a real acquaintance or friend of that juror. And Informant C may be a journalist because, it looked like they were fishing for a story.
Let me hit a couple questions here because people are throwing up some, sorry, I'll get back to that question. There was a couple questions about the judge just made an order of impoundment. What is that? Is that just continuing the impoundment of her car?
I guess. I don't know.
Yeah, I don't know the answer to that. And then somebody else said, True Crime said they sent it to me. So I'll take a look at it later. I don't have it right this minute. Courtney R., were the jurors supposed to answer the verdict pages in order? If so, they should have checked guilty, not guilty before moving on. Did Bev get that form? So we're assuming that it's blank. We don't know. And they can skip ahead and go back and forth when there's 3 different charges because they have to discuss every individual charge.
Yeah, and I don't think they're instructed to what order they need to do the charges or what order they need to check the boxes.
T2. Defense not saying anything after the judge declared a mistrial. They also didn't have the information they have now, which juror A provided, right? Correct, but they would never have that. They would never speak to a juror before they'd be able to make an argument to the judge. Kevin, should the defense attorneys request a jury poll after mistrial is declared? Seems like it would be good due diligence to ensure instruction not to misinterpret more information. A lot of jurisdictions, it's not allowed. Thought I heard that lawyers weren't allowed to ask what the jurors' positions were. So if the jurors reach out to the lawyers and the jurors want to tell them about the case, that's okay. The lawyers can't pry into the province of the jury and talk about, try to dig into what was said, what wasn't said, and try to pull stuff out that could create issues. Do you have any issues with their discussions with the jury on this in this situation?
No, I don't. I think only if the jurors contact them, everything's fine.
Usually that's how it works.
Right.
Caitlin, is it possible the informants are lawyers for jurors hired to reach out to the defense on their behalf to keep juror anonymous to the public? Would that hold any more weight in a motion to the judge than a random Joe informant? I don't know. I'm sure there's going to be, just like there was in Murdaugh, they got to them, somebody paid them, they're on the books, they're on the media PR tour. I'm sure there's going to be allegations and stuff like that to come out. I just don't know anything more than what's in these motions that we're looking at. Michelle Bell, weren't there 2 attorneys on this jury? I have no idea. I haven't seen that confirmed anywhere yet. If not guilty on 1 and 3, how is she legally guilty of manslaughter? I don't get it. Please reread all the counts 2 and explain. So again, we talked about this in the beginning. Intent, count 2 was the most that seemed that could be an accident or that she was drunk. She didn't know what happened. She didn't mean to leave him there knowing there was personal injury like count 3. She didn't mean to hit him and hurt him or kill him like count 1. Wasn't the Scientologist rape conviction in trial 2 preceded by a hung jury in 1 with about 9-3 not guilty, but they still retried and convicted? I'm sorry, I did not follow it. Do you know what they're talking about? Michelle, did the judge poll the jurors when she met with them in the room? If she knows all of this, how does it affect her ruling on the motion? So I heard people say the judge went and talked to them and that there was no official poll done. I would be surprised if she did an unofficial poll and then didn't share it. That would be improper, to say the least. Don't you agree?
Well, were the jurors dismissed when she went in there?
I don't remember. It might have been after they were dismissed. So you think it would be proper for her to poll the jury and not tell the lawyers what she found out?
She certainly could. After it was dismissed, the case is over, it's done. She could walk in there and talk to them. Yeah, she doesn't have to tell the lawyer
before she lets them actually go. She tells them not to talk to anybody else, and then she uses that opportunity to talk to them as the judge, where they obviously think they are forced to tell her their answer.
I don't know how she approached it, but she doesn't have to tell everybody what she talked to the jurors about.
I think it would be improper for her to use her position to go back into that room and poll the jury where the lawyers don't get the opportunity to do that. Because it definitely, to them, feels like they have to answer her.
Well, how does it prejudice the case?
Well, if they're going to argue some kind of misconduct on her part, or that she knows things and is doing things on purpose, and that's why she didn't ask for them to poll on certain charges, and then she goes back there and does something like that, I think it's at least an appearance of impropriety, in my opinion. All right, Sandy B. Peter, judge came in and said jury was at an impasse, said she was bringing in the jury, then brought them in and read the note, declared the mistrial, excused them, never asked the lawyers anything. Lori, jurors already felt intimidated by the Alberts. Who knows if anyone else had intimidated them now? In my opinion, it will be hard for the jurors to be questioned yet again. I do agree it's going to be hard. Let's take a listen, or let's read the rest of this just so we can talk about what you're talking about with that intimidation. Today, informant C sent me 3 screenshots of a text messages exchange she had with the intermediary C. Informant C told me that intermediary C was reporting to her during this exchange what juror C had revealed during the Zoom meeting. So again, this one is not directly from the juror. The text message reads as follows. No consideration for murder 2. Manslaughter started at polling 6-6, then ended deadlock at 4-8. He or she was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, she voted no because the cause of death was twofold, hypothermia and head injury, of which he or she was convinced that the vehicle did not cause both. I mean, to me, that's wild. That's not even necessarily correct, because if you hit a body and you leave them in the cold, you kind of created the hypothermia with the vehicle as well. But this was not somebody who thought John O'Keefe was not hit by a vehicle. Even by the defense own affidavit here, this juror seemed to think that that could have been a possibility that he was hit by the vehicle, but that the vehicle didn't cause the hypothermia. And that's why he or she would have come back with not guilty. I find that interesting. The whole jury felt very intimidated by Higgins' presence at the end. People think that they were talking about the Alberts that were sitting there during closing, not Higgins necessarily, but he or she was not sure what he or she was going to do. He or she was going to lay low for a couple days to see what it takes. Hasn't ruled out anything. The jurors all have a group text going. Interesting. If it was no consideration for she have been acquitted on that count and hung on the remaining counts. Charges go back to the jury verdict. Slip was all confusing.
Can I stop for a second?
Yeah.
Go back. Something that happens all the time. The jurors have a group text going. It is phenomenally consistent that jurors in long-term trials become bonded. And they have group texts, they have parties, they go to each other's weddings. It happens all the time. So this group text going shows you have a jury that's very bonded here. And this is a complication when you bring them, if you bring them back in to interview them about whether or not they were or were not unanimous on those counts. Keep in mind, they're going to be talking to each other all the time. And that's a very common effect of this. It's a psychological impact that they have on each other for being closed in for so long.
And we have watched juror interviews of intense trials in the past. Like the last one we did was the Chad Daybell one. And that's exactly what happened. They talk about how they're bound together. It's an experience unlike any other that they've only shared with each other. So that rings true there as well. GP Dog said that the impoundment is sealed in Massachusetts. Okay. Carrie said, did you show up Robert Tragos the verdict forms? Yes. When it was happening, I showed him to him and talked about him. Reese's mom said the Scientologist trial was Danny Masterson. I know who that is, the actor. I know what happened, but I didn't follow the case at all, so I don't really have any information on it. Jen M said she impounded the list of the names of the jurors. Okay. Yeah, people are kind of confirming that for 10 days. Interesting. So maybe that's some indication that she is going to consider further inquiry here. All right. She should have been acquitted. I agree. So this juror says that Karen Reed should have been acquitted. Yes, the remaining charges were what they were hung up on, and the instruction paper was very confusing. So this one says the remaining charges, meaning not guilty on count 1, but counts 2 and 3 were connected. So there's a little bit of an inconsistency here between A, B, and C. What a great experience for him, her. Amazing that they let the Alberta something in the last day. He or she felt honored to be a part of it. He or she was redacted physical description of Juror C. Everybody else was from professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. That's the way it should be. Knew it was an intelligent jury. They will be studying this case in law programs for years to come, i.e. not how not to investigate and try a case. So not exactly a glowing report from law enforcement or the Commonwealth. If they agreed on no for murder 2, they should make that clear to the DA and the count. It's basically a case double jeopardy if she is retried on that charge. So it seems like even the jurors are considering making it known to the DA. And if that's the case, it should be an easy call for the DA, who's, again, seeking truth and justice, to not retry that charge. Based upon the description of Juror C given to me by informant C and confirmed by the redacted content of the above text messages exchange, I am able to positively identify which juror he, she was and confirm that he, she was a deliberating juror. Sign under penalty of perjury, David Yanetti. All right, hit that like button if you guys have not already. We're going to continue to dig in on what we think is going to happen now, what we think should happen now, and, of course, answer your questions. Alexis, Peter, and Papa George. If the judge would have had any idea of this, like she went back to speak to the jury after the mistrial, would she have an obligation to say something? So not an obligation, but I personally think it would be the right thing to do in the interest of justice. You don't think?
I don't think there's any law that requires her to say anything.
Christy, what's your opinion regarding the new attorney? My dad kind of already answered that. Megan Bell. So jurors didn't submit formal vote charge by charge, only the letter to the judge reads out loud. This feels less fishy. New phone autocorrect sucks. Yes, that's what it seems like happened. Based on, I think if they knew something different and there was more nefarious things going on, it would have been in this motion. Don't you agree with that?
Oh, absolutely. They had to put everything in this motion. They got to shoot the whole thing.
John, I'm not saying it's true, but there a relationship between AJ and KR. We should discuss it. I just don't know what to discuss about it. I don't know if it's true. I don't know if it's false. I don't know how it would affect the case. I don't know if there's a relationship between a defense lawyer and the defendant. What relevance do you think that has at this point?
Defense lawyer. I don't know. I mean, it would have to be something that affected the outcome of the case or had an impact on the case.
Right. And I just don't know at this point whether it is or not. I don't know if it's true or false.
And I hate to speculate on this kind of thing.
Agreed.
Yeah.
Anthony, cops in the Boston area are talking about Higgins admitting at a bar he pulled the dog off J.O. Again, I believe if that was legit, it would have come in a trial. The judge said she would be back to talk to the jurors after declaring a mistrial. What was said in that meeting? Did jurors tell the judge about counts 1 and 3? The judge seems like a witness for this. So to me, and you can correct me or add to this, judges always go back, thank the jurors, hand them their certificate of appreciation, maybe a check for their time, depending on the jurisdiction. Tell them that they're not going to be called for X amount of months or years, whatever it is in that jurisdiction. That's usually what the conversation is.
The judge doesn't normally ask their vote, but they go back there because, again, I don't know in Boston, but judges are elected. And so they always go back to these jurors because these jurors are all potential voters. So they go back and they schmooze them a little bit because jurors love judges. And so that's the whole idea. So there's a good chance she never even asked.
Kelly Mack, could third-party intermediary be legal counsel for the juror, or would that be made apparent? I think it could be. We've seen other motions where they just said the lawyer for the juror. It doesn't Based on the conversation and the fact that they're revealing their conversations with these people, I would guess no, but I guess it could be. Miles, any idea what given free counseling form is referring to, therapy or something else? So a lot of jurisdictions provide therapy, counseling for difficult cases, especially when you see autopsy photos, you deal with families and sad situations. Did you have something you wanted to add to that?
No. I was agreeing with you. You hit it.
Schrumfelt said, I'm a criminal defense attorney in North Carolina, having over 100 plus jury trials. My dad's in North Carolina right now. Never had a judge not share the jury question first and discuss options prior to the jury coming into the courtroom. I agree. Off topic, but I think Alec Baldwin has top of the tops lawyers. One male lawyer argued dozens of motions today without a notepad, looking forward to that trial. So I am going to cover that probably tomorrow, since we're going to do a YSL video still. This popped up today. There's just a ton going on to squeeze in. Danny Girl, would the private meeting that Beth had with the jurors make her a witness to what was said? Potentially, but unlikely at this point. We'd have to know more, right? We have to know more context. Right. It depends, as most lawyers like to say. How is the third party not held to hearsay? So they are held to hearsay, but this is not a trial. The judge can consider this. They can dig into this further. Different rules apply at different stages of the case. Yari, would the outcome of the trial change if the jurors initially mentioned that in the note they have come to a verdict on counts 1 and 3 but hung on count 2? So yes, they could have dismissed the count 1 and 3 charges.
Right. And it would have come squarely within that case that was cited in the motion where it said you don't actually have to have a specific form or you don't have to check a particular box. A written note saying they'd come on a verdict on 1 and 3, I think would qualify under that case as a verdict.
I agree. All right, here, this one's for you. PMD, does the FBI have all texts, phones of, oh no, you wouldn't know this, Alberts and crew? Do they really know what happened as opposed to the limited discovery acquired by the defense? Do you think they will be indicted? So here's the question for you. So we don't know the answer of what all they have. We know some of what they have and not others. They hired these independent experts. The independent experts that testified at trial for the defense were that they don't think, physically and scientifically speaking, as PhDs in this stuff, that it's possible that John O'Keefe was hit by a car. So knowing that that's what people told the FBI, what's going on, in your opinion, in the FBI investigation into this investigation? What do they need? What can we expect to come down? Are there guaranteed indictments? How long can something like this last? Now that it's been a mistrial, how could that affect their investigation?
I don't think the mistrial affects their investigation. I think they're going to do what they want to do when they want to do it. I think that they have tremendous subpoena power to go and investigative power. I mean, come on. You walk into a body shop about a car repair and the guy says, "Hi, I'm an FBI agent. I need to talk to you." The guy's going to talk to him. So they have tremendous resources and scientific resources available to them. I mean, the whole country uses the FBI labs. So, it can go on for years, which I've had investigations go on for years. I don't think they're going to be swayed by any of the stuff that's happening in the trial. I don't think they're going to care. I don't know if that answers your question or not, but
it's close enough. The judge allowed the O'Keefe family to thank the jury per Paul's interview. I think they would have let both sides thank the jury if they wanted to. Yeah. Lori said 406,000 subscribers. Congrats, Peter. Crush the like. Yes, hit the like button and make sure everybody subscribes, because this case is not over. Subscribe, hit the reminder bell. We're going to continue. AK said Weinberg site says criminal and appeals attorney. Interesting reversals listed on site. So I will just tell you, a lot of criminal defense attorneys are also criminal appellate attorneys. We do a lot of our own appeals. My dad and Pete did a ton of appeals when you guys used to do a lot of criminal defense. So it's not unusual that you would also do appeals. It's unusual. Mr. Ufferman, who has come on this show before, who my dad is good friends with as well, he focuses on criminal appeals and doesn't do just the normal criminal practice. Would this situation be handled differently if the juror had gone to the judge directly versus going to the defense? What do you think?
Well, if they go to the judge had to do that. You talk about the judge's duty. The judge would have a duty then to inform the parties of what that juror said. And then,
why would that be different? Why would that be different than her polling and the jury saying, "Yeah, we were unanimously not guilty on count 1"? Wouldn't she still have that same duty? I guess
if they said that, I guess she would.
I mean, come on, those charges should be thrown out, legally speaking.
I'm not so close-minded as I can't be influenced. Yeah, I think you might be right. You might have a point that maybe she had if she knew there was a unanimous verdict, she might have then had a duty. I think you might be right.
Okay. If the judge denies this, would this be a reason defense could raise on appeal, and how?
Yes, this would be an appellate issue, and they'd raise it because that's why they made this record. That's why they have the affidavits. That's why they filed the motion. They could appeal it.
Wouldn't they need more information to win an appeal than what they have here? I don't know. I just feel like
No, I don't. They might not need more information for an appeal. Well, like we've seen, writ of mandamus or writ of prohibition for a writ of mandamus, so that the order the judge to have that hearing to make the inquiry of the jurors. That's what they'd be asking for, is for the inquiry, and they could ask the appellate court for a writ of mandamus if they wanted to require the judge to have that hearing.
Yes, Rebecca, I'm ready too. What are we, a month away from August? Melissa, these lawyers keep things close to the vest. I think they might only be releasing enough to get a hearing. Thoughts? So I'll get your thoughts. I would disagree, because if they don't shoot their shot and the judge denies a hearing, you don't usually get a second bite, and then you've kind of missed your opportunity to throw your best arguments out there. So I would think they're throwing their best arguments. What do you think?
Oh, sure. It would be a mistake not to. Absolutely a mistake not to, because then you'll kick yourself later. Say, gosh, maybe I should have said more.
It's the same thing I've heard people saying, oh, the defense saved arguments for the next trial. Just wait, they have more. You don't ever want to do this twice. If you've got good arguments for your client, you use them. Nina Stanek, in your opinion, was it a mistake for the defense to present the alternative theory and not only go for reasonable doubt? So I think they should have focused more on reasonable doubt, but I don't think it was a mistake to provide an alternative theory. I just wouldn't have gone all in to the alternate theory personally. But again, I think these defense lawyers know this case way better than I do. They know all the dangers. They know all the arguments. But even based more on what we're hearing from these jurors, I think if they would have gone more into reasonable doubt, it seems like even some of the jurors that were voting with them still think John O'Keefe was hit by the car. They still did not necessarily buy the conspiracy, the cover-up, the fight inside the house, the Albert's involvement, but they bought a lot of reasonable doubt, and that they didn't prove this happened or that this caused that. So again, maybe they'll learn something from that, and we'll kind of have to see. Jennifer, Judge Bev was appointed by the governor of Massachusetts. Okay, interesting. And that governor has come out, I don't know if it's the same governor, but and been harshly against Proctor. I saw a bunch of people saying Proctor has been suspended without pay now, not with pay, since he had his administrative hearing. So we'll cover that on another video. We've been going an hour and a half, Dad. Thanks for joining us. Thank you to everybody that came on and joined us. Please make sure you hit the like button if you have not already, and make sure you subscribe. That's all we've got for this video. Keep an eye out tonight. Hopefully we'll be able to record and get everything posted for YSL. Tomorrow we'll start hitting Alec Baldwin. And then that's going to probably be a daily thing for the next couple weeks. Somebody said, Peter, you misinterpreted the juror's note. She said they didn't believe Jawa was hit by a vehicle at all. You misread it. So I know that that's what people are going to say. Okay, so let's just bring it up, because, again, a lot of the stuff has been kind of frustrating. And I'm not saying you're doing this, Tyrod, because I don't think you are at all. But you're giving me an opportunity here to point something out. It's important to watch these videos. They're long videos. Clipping things out and aggregating it or trying to say I said certain things it is frustrating, but I pretty much ignore it, and I stand on kind of what we say in these long form videos. And I understand you're saying I misinterpreted, so maybe that's different. Okay, but then you said I misread it. So let me bring back up that part. Where is it? Wasn't it in this one? All right, Juror B even thought she hit him on purpose. Yeah, it's here. All right, murder 2, manslaughter, death was twofold. Where is it?
Are you talking about, there's a mention in the other affidavit about it?
No, look, it's right here. I mean, it says, I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. So if you want to say I misinterpreted it, this sick here is kind of indicative of maybe they just meant to say or even thought she hit him. But again, the actual reading of it says hit him on purpose twice. So I don't think I misread it. Maybe I did. I don't know. But this is how I read the actual words. But again, I don't see or think that she hit him with the vehicle, but it seems like maybe some of the jurors did, even some of the jurors that would have still voted not guilty. It was written wrong, people are saying. Yeah, I agree. I would think it's written wrong, but it's hard for me to say that with absolute certainty without hearing from the juror. All right, that's all we got for real this time. We're going to take off and get out of here. What happened to the new guest? This is the new guest, guys. Peter, it was impoundment of the jurors' names. Okay, we got that. And just Jen, any chances this can turn into a civil suit? Yes, but again, I think they'll have a better chance if they get a not guilty verdict eventually. All right, we got to run. Thank you, everybody, for joining and hanging. Somebody said not that part, Peter. All right, well, I've read every word, so maybe I did misread part of it. If I did, it's on the screen for us to read together. All right, that's all we got. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.